In this lecture, we will discuss another important leading case and the landmark judgment relating to Bhopal gas tragedy, that is M.C.Mehta vs. Union of India, where exactly the very doctrine of strict liability which was innovated by Justice Blackburn in Rylands vs. Fletcher, an English case in 1868, how it was modified by the apex court into absolute liability, and regarding the very facts that regarding the facts relating to build artificial reservoir in the particular leading case, that is Rylands vs. Fletcher, where it flooded the neighbor's mine and caused destruction and damage. So, in the very judgment delivered in Rylands vs. Fletcher case in 1868, the judgment delivered by Justice Blackburn, who innovated and developed the new doctrine of strict liability, and that doctrine of strict liability is being codified and being modified by the Supreme Court of India, and in relating to that, how it turned into absolute liability, and in that context we would like to discuss also the relevant factors relating to the Shreeram fertilizers industry and the death relating to Oleum Gas. And before that, we would like to discuss the Bhopal gas tragedy and which led and the very background of that particular leading case in on December 2, 1984, a small leak of methyl isocyanate gas was noticed from the Union Carbide India Limited factory at Bhopal on the morning of 3rd December 1984. A form of methyl isocyanate gas was there in the air, leading to deaths of thousands of people. According to one estimate, 3,800 people died immediately, out of which most were in poor slums. Adjacent to the planned estimated number of deaths in the first few days was more than 10,000 and reported 15,000 to 20,000 premature deaths in the next 2 decades. After the incident, Union Carbide Corporation of United States of America tried to deny being responsible for the incident by shifting the matter towards Union Carbide India Limited by trying to make the point that the plant was fully built and operated by the Indian subsidiary, that is the Union Carbide India Limited. In consequence, in March 1985, the Government of India enacted the Bhopal Gas Leak Disaster Act to ensure the dealing of claims arising after the incident speedily and equitably. This made the government as the only representative of the victims in the legal process in and outside the country. The settlement was made by the Supreme Court of India with Union Carbide Corporation, in which Union Carbide Corporation agreed to take the moral responsibility and paid a claim of $470 million to the government, which was negligible compared to a multi-billion-dollar lawsuit which was filed by an American lawyer in a United States court. This amount of $470 million was based on the disputed claim that only 3,000 people died and 1,02,000 suffered permanent disabilities, according to Bhopal Gas Tragedy Relief and Rehabilitation Department. By the end of October 2003, compensation was awarded to 5,54,895 people for injuries received and 15,310 survivors of those killed. After this settlement, the matter was placed entirely under Indian jurisdiction. The government was blamed for not having appropriate laws for environmental safety and for settlement of claims through the establishment of liability. If this kind of proper laws would have prevailed, then the victims of the incident would have got better compensation, and it would have been difficult for Union Carbide Corporation to get off the matter, as after the breathtaking tragedy, the Indian government passed and implemented the Environment Protection Act of 1986 under Article 253 of the Indian Constitution. Its purpose was to implement the decision of the United Nations Conference on the Human Environment of 1972, which was held at Stockholm in Sweden, to provide protection to an improvement of environment and prevention of hazards for humans, plants, other living creatures. This act strengthened the regulations on pollution control and environment protection by hazardous industries. The act provides the center with a lot of power to take all necessary actions required for the protection of the environment. It enables the executive wing to issue notifications and orders, which becomes guidelines for the administrative agencies. Basically, it provides the center with the power to make rules for environment protection. The Act has 7 schedules especially laying down the rules for emission or discharge of pollutants from industries, prescribing emission of smoke, etc. from vehicles, provides a list of authorities to be approached in case of any discharge outside the prescribed levels and standards, as under Section 25 of the Environment Protection Act 1986. Another set of rules was passed, the Hazardous Waste Management and Handling Rules 1989. It includes the management of 18 categories of waste, basically all toxic chemicals which could be stored in industries and used for different purposes. Some categories of waste which are included in this are metal finishing waste, waste containing water-soluble compounds of lead, copper, zinc, etc. It issues the notification that the one generating this type of waste or the one operating the facility which generates this type of waste is responsible for the proper management and handling of the waste. The Environment Impact Assessment Notification of 1994 includes almost all kinds of activities which could harm the environment in any way. Through this notification, an impact assessment of any project became mandatory. The central government is required to carry out an environmental impact assessment on a large scale before passing any project listed under the notification. It also establishes a right to know, that is, public hearing, through which the common man who would get affected by the project is given the chance to speak out and made aware of the project. Basically, a lot of transparency was included in the system for the validation of any developmental project. So the journey begins of legal principles cannot be easily understood through a case study of very landmark case M.C.Mehta vs. Union of India. So the principle of absolute liability was established by Supreme Court. After one more gas leak, though not a major one like the Bhopal gas tragedy, and that was in Shreeram Fertilizer factory in New Delhi on 4th December 1985, where the oleum gas was leaked from the bursting of tank containing oleum gas, which was caused by human and mechanical errors and not by any third party. This concept is of utmost importance and having relevance even today. The Bhopal gas tragedy was an incident which opened the eyes of the legislature and made their attention available to the environment and its protection. Even before this tragedy, laws such as the Water Act of 1974 and the Air Act of 1984 existed. But the Environment Protection Act provides an umbrella to central government for the coordination of various state and central authorities established under these previous laws. Therefore, it would not be wrong to state that had the proper legislative framework would have existed, even either this tragedy would not have occurred or the sufferings of the people could have been made less. So, the very principle of strict liability that we would like to discuss, which developed by Lord Justice Chancellor Blackburn in the important English leading case Rylands vs. Fletcher in the year 1868, and as regarding the very fact of the case, Rylands was the plaintiff and Fletcher was the defendant in the case. Plaintiff was the occupier of the mine and defendant whose mill in the neighbor to the mine, and they proposed to make a reservoir to store water for the purpose to use in a mill and another adjacent land near to it. Defendant took the help of agents to construct the reservoir while making, and that reservoir was an artificial reservoir. They did not take reasonable care and precaution, and due to heavy weight of water, and the shaft broke and the water passed into the mine of the plaintiff, which caused damage to the plaintiff. While giving the final decisions, Lord Justice Blackburn distinguished between the natural and non-natural use of land. So, under this important English leading case Rylands vs. Fletcher, the court declares it as a principle of strict liability. While the Supreme Court of India got the chance to make this principle when a petition was filed under Article 32 of the Constitution of India, emerged in the form of public interest litigation. So the very famous case M.C.Mehta vs. Union of India, as was filed in the court of law as a public interest litigation for the incident which took place on 4th December to 6th December 1985 due to the leak of oleum gas, which was leaked from the Shreeram food and fertilizers industry in Delhi, and became famous by the name of Oleum Gas leakage case. During this incident, one of the advocates of the Sajari court died, and many others were also affected by it at a large number. So, an environmental activist, M.C.Mehta, approach Supreme Court of India and file a public interest litigation so the court may take action on the matter and decide the liability and responsibility of the persons for the incident. During that period, the court was going across the most active states and denied to follow the ruling of Rylands versus Fletcher's case, as Justice P.N. Bhagavati said that he cannot afford to evolve any type of guidance and any standard liability under constitutional norms. Law has been made to satisfy the needs of the rapid changing society and keep aside the development of the economy of the country. All the industries which are set up in the residential locality and engaged in hazardous toxic chemical which will affect the health and safety of the people of locality who an absolute responsibility for the community to ensure them no harm or damage will be caused to them. The industries are under obligation to use the highest standard amount of equipment and machines to avoid damages to a large number of the population residing nearby. They should use a filter to avoid pollution. Certain guidelines are given under environmental law which needs to be followed by every industry which is engaged with the toxic and hazardous substances to avoid pollution. If they don't follow the guideline, then their license will be cancelled by the inspection team. So now we can easily distinguish between both the principles of strict liability and absolute liability. Strict liability is applicable to all the things which exist in a place, but for absolute liability, things causing harm or damages, and it must be in relation to hazardous and toxic substance. So, on this note, the court has narrowed down the principle of strict liability. But the more exciting and happening part of it is that the liability of the defendant become absolute in every manner. No matter what the damages will be caused due to the negligence on the part of the defendant, no matter how the hazardous items escaped, what the reason is, but the consequences had to be faced by the defendant only. Once it is proved by the plaintiff side that the damage was caused by the defendant through hazardous item, no excuse will be applicable to it except the case of act of God, which is an exception to liability as under law of tort. Court laid down that measure will be taken to finalize the amount of compensation should be within the capacity of the enterprise. The very rule laid down under this case was also approved by the court in Charan Lal Sahu vs. Union of India. In 1991, the court held that defendant has absolute liability for the act he cannot escape by saying that he took all the reasonable care on behalf of his part. So, now we would like to conclude our lecture on this very important leading case, that is M.C.Mehta versus Union of India, in particularly relating to the leakage of Oleum gas from the Shreeram food and fertilizers industry, which caused the instant death of an advocate of his court and death of other people, and in consequence to that he filed an public interest litigation under Article 32 of the Constitution, where the judgment delivered by the then Chief Justice P.N. Bhagavati regarding the very responsibility of an industry compensate to the sufferers the very evolving the very doctrine of absolute liability. So, in conclusion, would like to express that after this act, the very principle of absolute liability is given more emphasis, and the Indian judicial system took an affirmative step by adopting this principle. Bhopal gas tragedy was an event whose effect can still be seen in many newborn children who were born with abnormalities. And it was very important to give direction to all the industries established near the residential area to take all the precautions and not to play with the precious lives of people. So hereby we made reference to the observations and the ratio decision made in particularly in the leading cases relating to Bhopal gas leak tragedy, and also made analysis of the principles laid down by the apex court in evolving the very doctrine of absolute liability in relation to the Oleum gas case, in relation to Shreeram food and fertilizer industry, and which was challenged by an environmental activist, Mr. M.C.Mehta, as a public interest litigation under Article 32 of the Constitution of India and the very coinage of the doctrine of absolute liability and the responsibility of an hazardous industry was itself made by the then Chief Justice P.N. Bhagavati of the apex court.